in on the call, welcome. It's great to have you with us. Thank you very much indeed. We did arrange this one quite last minute. I mean, I didn't know about this, Gordon, until you sent me that email, so thank you very much indeed.
Yeah.
It kind of slipped under the radar. And I know a couple of people that I've spoken to subsequent to that have said, I did not know this. So thank you very much, Gordon, for getting this organised so quickly. There is also an article on the, I think I put it up on the EuRA website, it's under articles, or you can just search for EU Privacy Shield and that article will come up. It actually is part of Gordon's wider assessment of the state of legal that we publish in every European, which is coming out at the beginning of August. So again, thank you very much for that, Gordon, because if you do want to go back, obviously you'll be able to access this recording on YouTube, but if you want to go back over the nitty-gritty of what Gordon's going to talk about, then you do have access to the article on the website. So again, Gordon, thank you very much indeed.
Yeah, just to mention, Dom, that I've also loaded it onto the peer group, the EuRA peer group.
Great.
So yeah, everyone has access to our current commentary on it.
Excellent. And you can find that peer-to-peer group on LinkedIn. Again, just search EuRA and you'll see all of the groups. You've got the official members group and then you've got the peer-to-peer sharing group. So this is another thing to say, if at any point you've got not just a question about Privacy Shield, but a wider question about legality within mobility, Gordon monitors that group and is very happy to answer questions, and it is free legal advice, so take advantage. Right, I think we're just past the hour, so it's probably best to begin. For those of you who don't know Gordon Kerr, Gordon is our strategic consultant for legal services and legal guidance, and Gordon writes and publishes our legal guide, which contains immensely useful information about contracts and everything else that's to do with mobility, as well as our guide to GDPR. They're both available on the website. You do need to be logged in because obviously they're only free to EuRA members. But Gordon has been working with EuRA for the last few years, but prior to that was in independent legal practice, but also running a large international RMC, and so comes at this from a real perspective of expertise. So Gordon, thank you again for being with us, and thank you for bringing this up so quickly. So today's briefing is obviously about the invalidity now of the EU-US Privacy Shield. This is a complex topic, and thank you to people who've been in touch in advance. There's a couple of questions that came through my email, which we'll touch on. And like I said before, if you were in earlier, there are 3 ways to ask questions. You can put a note into the Q&A box, which you'll see at the bottom of the screen. Just drag your mouse down to the bottom of the window. You can put a note into the chat box, or you can press the hand symbol and it'll tell me that you want to say something, and I will unmute your microphone. Gordon, so first of all, thank you very much for being here. What is EU-US Privacy Shield, and why is it important to our industry?
Right, the Privacy Shield is necessary because of a fundamental difference in the way that the United States and the European Union approach privacy rights of individuals. Now, everyone will know now about the GDPR, which is like the gold standard privacy law in the world at the moment. So it makes sure that the rights of anyone resident in the European Union has very strong privacy protection. Now, by contrast, in the United States, there's always been far less emphasis on privacy rights. And I guess you could compare it with it's more important that businesses can use data in ways that make them more efficient and give marketing opportunities, etc. And that is only very slowly changing. I think California, for example, brought out quite an advanced privacy law last year. So it may change at some time in the future, but it's certainly at that federal legal level, there is nothing equivalent to the privacy rights that we enjoy in Europe. Now, that causes a problem if a European company wants to transfer data to the United States, or an American organization with offices in Europe wants to hold their data centrally in the US. And the way of getting around this was to enter into a special arrangement whereby organizations could apply for accreditation and basically say that, well, we are an American organization, we're holding this data in the United States, but we promise that we will handle the data broadly in accordance with European law rather than the lower standards of American law. And so we had something, I mean, it actually goes back, I think, to about 2000. The first arrangement between the European Commission and the United States government was something called Safe Harbor. And most of the relocation companies signed up for that. And then in 2015, a privacy campaigner in Europe, a very pesky Austrian lawyer by the name of Max Schrems, took Facebook to court. He complained that his data, which was held by Facebook, was being transferred to the United States without his consent. Big court case, and as a result of that, Safe Harbor was declared invalid. So that was 2015. US government, European Commission get together because businesses on both sides of the Atlantic are saying, this is an impossible situation now, you know, tell us what to do. And basically, they got together and came up with this new idea called the Privacy Shield, which basically had stronger controls around it. It put stronger obligations on companies holding data in the US for EU citizens. So it sounded like we've got the solution, and most relocation companies signed up and became accredited under the Privacy Shield, and everything returned to normal. All the data could be held in central servers. And I mean, if I go outside the relocation industry for a moment, I mean, we're talking about thousands of companies and all kinds of data, including, for example, we're on the Zoom system just now. Well, Zoom data is held in the United States. So, and Zoom relies on the Privacy Shield. So that's why it's so important. And in the context of relocation, because personal data is, you know, at the heart of our industry, and we, by definition, we're transferring it internationally all the time, then it's just so important to us as an industry. And now we're doing something that has just been declared invalid. So that's why it's so important.
I mean, that's fascinating. I didn't realize that the Safe Harbor, I knew it had come to an end in privacy shield, but I didn't realize it was as a result of a legal action. So this was a decision by the European Court of Justice. Why have they declared Privacy Shield invalid? You mentioned Max Schrems, but that's in relation to Safe Harbor. Why Privacy Shield?
Well, there's a connection. Guess who brought this current action? The same Max Schrems, who must be a real hate figure in the European Commission and in the US government, because this is the second time he's brought a successful action. So Safe Harbor was an action against Facebook that almost incidentally brought down Safe Harbor. This time he was suing the European Commission, effectively saying the Commission have entered an arrangement with the US government which breaches European law, therefore should be declared invalid. Now, the basis of his claim, why he said it's invalid, is that when data goes to the United States, okay, the companies there are signing up to European standards of data protection, but it doesn't prevent, for example, the FBI and the National Security Agency in the United States from accessing that personal data. So that is actually the problem. It's nothing to do with companies being slack with how they handle data. It's almost a matter of principle, because under American law, take the FBI, for example, they can access personal data held in servers in the United States. And my understanding is that can actually be done without legal action, without going through a court. These are almost like statutory powers, we would call them. So that was Max Schrem's claim that there's no way a European citizen is getting equivalent protection in the United States because the security services there can access the data. And no, it sounded like a bit of a technical argument, but to everyone's surprise, the European Court of Justice agreed with Max Schrems and said, yeah, European Commission should never have entered this agreement with the US government, and we are declaring it invalid. And actually, just to quote from a lawyer, this was quoted in the Times a few days ago, but it kind of puts it into perspective. Lawyers are not known for using wild language, but this data privacy specialist, one of Britain's leading lawyers, said, and this is Friday morning after the result came through, "It's been mild hysteria this morning. This is essentially a complete ban on the transferring of personal data to the United States. It is such a nuts outcome that it is almost completely unworkable." So, that was a kind of normally rational lawyer describing it in these terms. Now, I think in practice, probably if he'd reflected for a few more days, it's not a complete ban on data moving to the United States, but it certainly was a shock to the system and causes, a lot of problems.
That is fascinating. So, and like you say, from initial interpretation, pretty broadly applicable to the whole, the whole data environment. So what happens now?
Well, I think firstly, we will have a period where the European Commission and the US government try to get together and say, can we sort out this mess? Which is what happened last time when Safe Harbor collapsed. In fact, there was a period of grace given to all organizations who were dependent on Safe Harbor. Basically, the European Commission said, don't panic, we're going to discuss this with the US government and we'll see what comes out of it. In the meantime, we won't declare it illegal to transfer data to the United States. The problem this time is European Commission, in a sense, now has to go back to the US government and say, well, we did this deal with you last time called the Privacy Shield, and we agreed, we thought that what you were doing with data in the United States was acceptable to us. Now we're saying we need a better deal, we need a stronger deal. But the only way around it, if the essence of the problem is the ability of US security agencies to access that data, then really, unless the US government says, oh yeah, that's fine, then we will change the practices and legal status of the FBI and the National Security Agency, then I can't see a solution here because it's fundamental. Unless the US government was so desperate to do a deal with Europe that it was going to change its national security practices. So I can't really see room for negotiation here, and that really is the problem. The deal was done 5 years ago, and the European Court of Justice has just unscrambled the deal. Yeah. So that's difficult.
That's amazing. And just slightly odd, can you put that into the context of how security agencies in Europe are able to access data? Because I'm assuming certainly here, MI6 need to go to law in order to access personal data, right?
Yeah, I mean, this is a very complicated subject, and of course, every country within the EU has its own status, legal status of its security organizations. And I mean, this was a point I was going to come on to later, but since you raise it, it also causes a problem for the UK, because it may be that let's say the French and German, the Dutch security agencies have less access to personal data than the UK security agencies do. Then could this mean that there's going to be a problem coming up in transferring data from the European Union to the UK after the transition period ends, so from 1st January next year? The fact that this judgment focuses on the ability of security agencies to access data could cause problems for the UK as well. So the implication of your question, you're quite right. American authorities do have stronger rights than European authorities do, but then look at Europe, and I'm not sure that there's a problem for the British authorities as well in the same context. And again, it's every country would say we place the defense of the realm, our security arrangements, and our part of that ability to offer security to our population is the ability at times to look at personal data and in whatever shape or form that's held. So it's it's a problem, but yeah, highlights that American agencies have more powers than their European equivalents.
So what should EuRA members be doing?
At a practical level, the first thing is to keep an eye on the websites of your own national data protection agency. In the UK, that's called the Information Commissioner's Office, ICO. And when I last looked a couple of days ago, they didn't have any advice yet on, heck, what do we do? We currently transfer data to the US under the Privacy Shield. What can we do? I suspect there are a lot of very active and urgent discussions going on between these national authorities, because they will want to come up with one solution. But that's one thing to look out for, the advice that comes out in your country. But beyond that, the technical answer is that in this same court case, the European Court of Justice did say that it was still valid to use something called standard contractual clauses. Now, this gets a wee bit dull, but basically the European Union produces forms of document that can be incorporated into contracts which transfer data around the world. So if, for example, I was transferring personal data to Australia, which is not an approved country, there's something called an adequacy decision. Whenever the European Union looks at the data protection laws in a foreign country, they can declare it adequate, and that means it's easier to transfer data there. Now, the US wasn't adequate. That's why we needed the Privacy Shield. Countries, it's a relatively small number, maybe about a dozen countries that are considered adequate or equivalent to European data protection laws. But that's why I mentioned the example of Australia. It doesn't have an adequacy ruling, which means that if I transfer data, I have to have a more complicated contract with the receiver of that data in Australia, and it has to include these standard contractual clauses to the letter. I can't change the wording at all because it's European Commission approved wording. And so if I've got hundreds, maybe thousands of contracts out there in various parts of the world, I would be having to now contact all these suppliers, contractors, partners, and say, can we amend our contracts, please? And that's exactly what was happening when Safe Harbor was declared invalid. I mean, I was a lawyer in private practice at the time, and I was acting for a lot of American relocation companies and advising them how to adjust their contracts But it was easy for me, you know, in the sense I was just saying, these are the clauses that now need to go in all your contracts. But these guys were having to maybe contact, you know, hundreds of suppliers each and get their agreement to change the contracts. So it's a big bureaucratic and administrative hassle. And last time round, a lot of businesses said, well, we'll just wait to see if the Commission can do a deal with the American government. This time, it's less likely, but I guess you wouldn't want to take immediate steps to be doing, you know, hundreds of new contracts unless, you know, we do hear, and that's why I go back to the data protection authorities in different countries. Let's see if they do come up with some other means of allowing data to be transferred. But that at the moment, if a client was coming to me, I'd be saying, I'm sorry, you're going to have to amend all your contracts. And this is particularly a big deal, of course, for the relocation management companies, you know, with their networks of suppliers and moving data around, and particularly because they will usually be holding that data in their main servers in the United States.
So then within our supply chains in mobility, whose responsibility is this? Who does this fall on?
Okay, the technical answer to that is simple, in that if you are an EU business, you're the one who is legally responsible, because you have to comply with the GDPR, for any data transfers that go outside the European Union. So I may have a tiny business in Edinburgh, and if as part of my business I transfer data to a major client, major company in the United States, then I'm legally responsible for making sure that that personal data is properly protected. Now, that's a technical answer. I'm sure that in practice, all the relocation management companies will be taking the initiative here. And again, this judgment only came out, well, exactly 7 days ago, so it may be a few weeks before really people work out, this is what we're going to do, this is who we're going to do it with. They will be checking with their own legal advisors, of course. Some have in-house legal departments. They are going to be scrambling around just now, but nobody will want to act too quickly just in case a better solution comes along. But if it feels to me just now as if that's where we're going to end up, with these rather cumbersome contract clauses. And we know already how relocation service contracts get longer and longer. This is going to be another few pages added in if any personal data ever goes to the US. So it's a bit messy, but there is technically a solution. Having said all that, the one thing that would concern me still is if logically we're saying the reason we can't transfer data to the United States under the Privacy Shield is because security agencies in the US can access that data, then really the same argument could be made, even if you've got contractual clauses in your contracts, then that doesn't prevent security agencies from accessing that data. So it's it really is a mess. You know, logically we can go down the route of these contractual clauses, we can sort out the admin, but I would still have a kind of concern that Max Schrems is waiting to bring another legal action in the near future.
I think the National Security Agency have got him quite high on their lists at the moment. So if you think about, because you mentioned that the whole adequacy decision and how that's going to affect, just briefly, the UK, does that mean, because you made a point to me that, you know, could that mean that the UK could potentially be seen as a backdoor to transmit data?
Yeah, I mean, again, this decision really does impact on Brexit because the UK thought it had sorted out a really neat solution. The GDPR is now incorporated into UK law, so that makes Britain equivalent to Europe, and therefore an adequacy decision was seen as probably a formality, albeit it hasn't been granted yet to the UK, but before the end of the year, maybe as part of a deal, if there ever is a deal between the UK and the EU, then that would form part of it. So that was one part of it, and the second part for the UK was the UK government was going to duplicate the privacy shield, so there would be a UK-US privacy shield. Just as Switzerland has done, there's also a Switzerland-US privacy shield, identical to the EU one. And so Britain would be in the middle of the US and the EU, and data would flow and everything was going to be fine. That's just been thrown up into the air now because, firstly, will the EU give an adequacy decision to the UK when they know it may be attacked in court on the same basis as Max Schrems has done already? Partly for the reason I mentioned earlier, that the UK security authorities may be regarded as having too much access to that data. But secondly, because the UK will be transferring data onward to the United States under its privacy shield or whatever it may now be called, therefore the EU would be worried that, the UK was a backdoor for getting around problems of transferring data onwards to the US. And I mean, some commentators are suggesting the UK may have to choose between free data flow to Europe or free data flow to the US. So it really is, again, a mess, and we can only hope that over the next few weeks that we get clarity on that.
It's huge, and I mean, from the point of view, I remember a couple of years ago we were asked to go and talk at the Relocation Directors Council in the US on how GDPR was going to impact, and by that time, you and I had lots of conversations with Tad. We were basically saying it's not as bad as everyone thought it was going to be. But the real debate hinged around privacy. What is considered to be private data? And Sylvia's just put in the chat box that she's being advised that even an assignee's email address is considered private. So how does that impact on a wider level? And I'm just thinking purely selfishly, how does this impact on the fact that most of us now are using cloud-based solutions, and most of those cloud-based solutions are based in California? What does that mean?
Yeah, well, again, if I give a technical answer to that, it would be these cloud-based organizations will have to make sure that they have these clauses in their contracts with all individuals. So for the moment, that would technically allow them to continue having the servers in the United States. I guess at a practical level, many of these cloud software providers may think about, well, this is going to be easier now to have servers in the European Union, or a server there. Of course, if they've already got a server in the UK, will that be enough going forward?
Yeah.
So that, a UK server may not satisfy Europe going forward. But yeah, it really, this affects thousands and thousands of organizations, from the big tech companies, from the Googles, the Facebooks, etc., right through to, a 3-person DSP in the European Union that gets instructions from a US headquartered relocation management company.
Very good point from Rob Fletcher. Given the $7 trillion transatlantic economic relationship, do you feel that governments will fix this?
There has to be a fix to it, because there can't just be a stop on data. And that's why this one is genuinely frustrating, both from an American point of view and also from a European governmental point of view. This court decision was not meant to happen. So there will be a fix. The question is, will it be a kind of hairy bureaucratic fix along the lines I'm mentioning, which could still be challenged? Or will there be a government-to-government new agreement? But as I've mentioned, there are problems in that because I don't know how far the Americans would be able to go. But yeah, you have to imagine that there will be a political solution ultimately, because yeah, I mean the idea that a privacy campaigner, no matter how good his motives, can bring down global trade to this extent. It's almost as if the judges here have ignored kind of public policy, wider commercial issues. That's not for me to question these smart judges.
But I'm guessing that what you're saying behind that is that this was taken on a purely legal, very technical basis without really, like you say, looking at the wider implications of the usefulness of this as an actual piece of legislation.
Yeah, no, totally, yeah. So it's, I think those who say, look, let's not panic about this, and that's why I quoted the panic-stricken lawyer at the beginning.
Yeah.
I think, over the last few days, people will be obviously consulting with their lawyers, in big companies, but I suspect there'll be this sense of let things settle down. Nobody's going to be prosecuted over the next week or two for transferring data under the Privacy Shield. That's, you can't just suddenly switch that off and switch on something else. And hopefully that gives time for sort of common sense arrangements to be worked out, on a political basis.
Rob Fletcher's asking a question, and I'm just, Rob, correct me if I'm wrong. He's saying, were the standard contractual clauses also invalidated by the ECJ ruling? I'm presuming you mean the ones that were put in place after Safe Harbor.
Yeah, the standard contractual clauses were still regarded as valid instruments to use, but almost companies are meant to, in a sense, look carefully at the countries they're using them with and still have to be satisfied that there will be adequate protection offered in that country. So it was a kind of, yes, you can still use them. Yes, they're still valid, but there's an expectation that companies will use them in a kind of thoughtful way that complies with EU law. And that's pretty unsatisfactory. It's, again, it almost invites guys like Max Schrems to raise actions saying, well, Facebook are still using these clauses to send my data to the United States. I object to this, and before you know it, it's back in court again. So it's, but technically they're still valid, yeah.
So Sylvia Ehrlich yesterday sent me a question, thanks Sylvia, from Intrepid Relocation in the US. We were recently approved for renewal of our Privacy Shield, and we were never made aware that there would be issues with EU requirements and alliance. What happens now, and does a small US firm meet with EU guidelines having Privacy Shield certification, or is it no longer considered of value? I mean, I know you've answered bits of that, but...
Yeah, I mean, I feel very sorry for US-based organizations, particularly smaller ones who've, gone through all the hoops to get accreditation. It's done through, I think, the Department of Commerce in the US, and now find that effectively it's valueless. Yeah, they have an accreditation that's just been declared invalid. But again, I would return to the practical point. I wouldn't panic yet. Let's see what the politicians and the smart lawyers come up with now as alternative arrangements. And it may be that they will officially declare that although the Privacy Shield has been declared invalid, there will be a specific period of grace to allow companies to adopt new methods. I mean, an alternative method is where you go to each individual whose data is being moved and get their specific consent, and it has to be consent freely given. So there are kind of problems with that, but technically you can get an individual's consent to send their data anywhere as long as they are fully informed and give the consent freely. But again, that's not a practical solution for most people. But I guess if you're a small business and wondering, can we find a practical way just to protect ourselves, then maybe you get individual consents. But yeah, it's not a solution to the mass of data that crosses the Atlantic.
Yeah, that's interesting because Rob Fletcher just asked exactly that. If I can consent, what does it matter? I mean, from that point of view, again, you kind of think, well, so things that are already in place, and I guess this is what's going to be concerning a lot of the relocation as well. I'm just thinking from our point of view, we use an app developed in California. It contains all of the personal data of all of our delegates at all of our events. Is the responsibility going to be on that company to make themselves compliant, or do we have to, all of us as organizations, have to then deal with those suppliers? Whether it's somebody, for example, a lot of our members use US-based technical solutions for tracking and that kind of thing, for relocation tracking. Whose responsibility is it at the moment, or can we just forget about it for a while and wait and see what happens next?
Yeah, well, as I say, I think we don't need to react immediately. We need to be aware there is a problem here, but let's wait to find the best solution possible. Now, in terms of whose legal responsibility it is, it definitely is with the organization in the European Union.
Right.
So now, let's take the situation of a DSP in the European Union and an RMC, which is headquartered in the US and its servers are in the US. So that obligation is with the DSP, but in practice, rather than the DSP having to come up with and incorporating standard contractual clauses into their contracts, what I'd be saying is, at a practical level, contact the RMCs that you do work for, and well, I suppose it sounds a bit arrogant, but ask them if they are aware of the decision that invalidates the Privacy Shield and what are they doing about it. Because the RMCs will definitely want to take the initiative here. They're the ones who issue the contract. If they're going down the standard contractual clauses route, they'll be the ones who are amending their contracts and reissuing them. So if I was trying to protect myself as a small European business, I would just be going out to these RMCs, and if I had any concerns, if I hadn't heard of any feedback from them, in 2 or 3 weeks' time, I might take the initiative and say, please confirm that you are aware of this judgment, and let me know what steps you're taking, because technically the DSP in Europe could be fined.
Sure.
Yeah, it's not going to happen quickly, but technically that's the problem.
That's the legal situation. Barry Potter, thank you for your question in the Q&A. Most global organizations, especially the large household names with whom we are working on a global accounts, will have data in the US, EMEA, and APAC. How is this impacted by the new rules, the US EU rules?
Sorry, can I just try and repeat the question? It's these global organizations that have some data in the US.
Yeah, some in EMEA, some in APAC.
Yeah.
Is it just the data that's held in the EU, not Middle East and Africa, that is affected by this rule?
Yeah, it's the European Economic Area, which is the European Union, and Iceland, Norway, and Liechtenstein, I think.
Okay.
So, but we tend to just talk about the EU, but it's EU plus others. And this only applies to data relating to EU residents. So in other words, people who have the protection of the GDPR, if their data in the course of any transaction is being transferred to the United States or can be processed in the United States. So I suspect this would even be if you're sitting in New York and you're the RMC and you can access the data on these EU citizens because your systems are it's all networked, then that in itself would count as processing. So it's anything that is ending up as being accessible for the parent company or the head office in the United States. It covers that data.
Yeah. Okay. Thanks. Yeah. Okay. Clear. Sylvia is asking, can EuRA provide a sample white paper that could be sent for privacy permissions? I think that's probably something we'll be working on, Gordon.
Yeah, I think we could certainly take an initiative here based on our knowledge of the way our industry moves data around and the kinds of problems that this is going to cause. So yeah, it's a very interesting thought, and
we will.
Because I think the relocation industry probably, in terms of its use of personal data, is a little bit unique. In terms of the directions that the data is going in, it's all over the world. It just so happens that many of the biggest organizations use servers that are located in the US, and that's why it's such the Privacy Shield has always been so important. But yeah, I think we're probably in a unique position to talk about the problems arising from this decision, what it means for small businesses and large businesses in our industry.
Rob Fletcher is asking, given the unlitigated challenges to GDPR, how quickly do you think this will be processed?
I think when Safe Harbor was declared invalid, that was in 2015, and it took the best part of a year until 2016 for the Privacy Shield to then be up and running. These are very complicated discussions. So if we're looking for when will there be an alternative to Privacy Shield, if indeed there is one, then yeah, it will take probably until the middle of next year. Right. But that's why the period of grace was specifically stated last time round. If there is any hope of an agreement, that's why I would expect there to be a period of grace again, because otherwise everyone has to rush out and get these contractual clauses in place.
Does anybody else have any questions? Please pop it into the chat box or into the Q&A. We are approaching the 45-minute mark, so I think probably the best thing to do, obviously, if any of you have a question for Gordon that occurs to you, obviously you can email him, Gordon at EuRA-relocation.com, or put a note into the LinkedIn peer-to-peer group. But I think probably what we'll do, Gordon, is keep, as things move forward, we'll keep doing these briefings.
Yeah, and I mean, I'll be looking out for anything that comes out either from the Commission or from the data protection authorities in Europe saying, this is what we recommend, because that's really what we need now.
Yeah.
We've got the technical solution, in inverted commas, which is not very satisfactory. So I'm hoping we get some kind of commentary coming out shortly once the officials have digested this result.
So we didn't have enough to think about, frankly, but there we go. So like I say, we'll talk about working on putting together some kind of policy document, a bit like we did with Martina for, working with COVID, a bit like we did with you for the GDPR guide, because I think obviously as time moves forward and we all know, what the implications are going to be, what we'll do is put something together like the GDPR guide, the first section of which was, this is what you kind of need to do. This is your internal audit as an organization to make sure that you're going to be compliant with whatever it is that sits in place of Privacy Shield. So very complicated, just more things to do, really. Gordon, thank you so much for bringing your lens to this very strange issue. And like I said, everybody, this will be live next week on the YouTube channel, and it will be, and there's still the article on the website as well, so you can download that. And as things change, we'll keep these things updated. So Gordon will probably talk about this again at the beginning of the autumn, or maybe even as part of the full forum, we'll bring this in. So we're using October 1st and 2nd, we're doing the EuRA Full Forum, which is no charge to anybody who is attending Seville, hopefully in March 2021. You'll receive your logins on the app for that next week. So I think probably, Gordon, what would be a good thing for us to do is structure this into that event as well. But before that, if things change, let's run another one of these. But in the meantime, we'll work on getting some kind of white paper policy in place. Gordon, thank you so much. Brilliant. Thank you to everybody who joined us for this. The next briefing at the moment is going to be on the thorny issue of your processes have changed in the light of COVID-19. Your pricing will probably have to change as well. Are you putting up your pricing, and who's going to pay, and all of that. So we're assembling a panel. If any of you think that you would like to be part of that, please contact me, and we'll get this going for the beginning, so the first 2 weeks in August. Gordon, thanks again for bringing what clarity there can be at this moment. And thank you everybody for attending. It's always great to hear from you. Thank you for nice comments coming through the chat box. And like I say, next week on the YouTube channel. Gordon, thanks again. Pleasure. Take care, everybody. Bye-bye. Bye-bye. Bye.